In opposing the application, the petitioners herein filed their grounds of opposition together with submissions also dated the 10th of October 2017. The petitioners submitted that this application is an abuse of the court process, is misconceived and bad in law. They contend that there is neither an error whatsoever that is being sought to be corrected, nor is there any clarification to be given. According to the petitioners, the question being raised has been determined by a court of competent jurisdiction in the minor KI decision, which was upheld by this court. Further, that the application is a mere attempt by the applicant to sneak and or lodge an appeal through the back door in regard to the decision in the minor KI decision. That the issue of the role of the chairperson as the returning officer of for the purposes of the presidential election was at the core of litigation in the decision in the minor KI decision, High Court petition number 207 of 2016, which was subsequently appealed to the Court of Appeal by the applicant via appeal number 105 of 2017. The petitioners further argued that this court became functus official upon the rendering of its decision as regards the presidential election conducted on the 8th of August 2017, and cannot sit to hear and or open up issues that had been previously litigated upon before the Court of Appeal. Further, they argue that this court has no jurisdiction to entertain the application herein or to sit as an interpretive court over the decision of a lower court. In addition, the petitioner submitted that pursuant to Article 140 of the Constitution, the mandate of this court to determine questions arising from the presidential election was time-bound, and the same lapsed within 14 days from the filing of the petition challenging the validity of the presidential elections. It is the petitioner's other submission that this application is merely trying and or purporting to ask this court to sit as an appellate court over its own decision and to cast doubts and aspersions as to the validity of this court's judgment rendered on the 20th September 2017. They submit that this does not fall within the purview of Section 21(4) of the Supreme Court Act. And to buttress this submission, the petitioners rely upon the case of Fred Outa, as well as that of Chandra. In addition to the above, they urged the court to rely on the persuasive decision of the High Court of Australia, in which it was held that controversies once resolved are not to be reopened except in a few narrowly defined circumstances. Further reliance was placed on the Supreme Court of Philippines' decision on the doctrine of finality or immutability of a judgment. It is the other contention that there is no disconnect between the direction by the Court of Appeal in the minor KI decision and paragraph 294 of this court's judgment as alleged by the applicants, in that this court expounded on the constitutional mandate of the chairperson of the Independent Electoral and Boundaries Commission to verify the results by checking whether there is any discrepancy in the forms 34A and 34B.